All right, in the interest of time, we can go ahead and get started. Hello, everyone, and welcome to the Environmental Law Institute's program, Community Lawyering for Environmental Justice, Part 5, recap of federal environmental justice legislation and regulations from 2022. This is the fifth part of our Community Lawyering for Environmental Justice series. If you've missed any previous parts, the other installments are available to watch back on our website at eli.org. You can find our full speaker biographies, an agenda, and a worksheet for today's program on the event page. We will post the link to the event page in the chat as well. Please go download the worksheet if you've not already so that you can fill it out throughout the program. I want to thank our wonderful speakers for being here today and for preparing great content for you all. I also want to thank our Pro Bono Clearinghouse team for assisting with preparation for this program. Before we get started, I have a few notes. First, regarding continuing legal education, while this event is designed as an opportunity for attorneys to participate in continuing legal education, ELI makes no guarantee that the course will be accredited for CLE in any particular state. Due to ELI staffing in our current capacity, we have only applied for CLE accreditation in California for this event. Our application is pending for 1.5 hours of CLE credit in California. Additionally, we are an accredited CLE provider in Vermont and Pennsylvania, so the course is automatically approved for CLE credit in those states. Many states offer reciprocity with the states in which we are pre-approved, so please check to see if your state offers CLE reciprocity with Vermont or Pennsylvania. If your state offers CLE reciprocity, you may be able to automatically receive CLE credit without filling out an application. Additionally, several states do not require CLE at all, so please check to make sure your state requires you to take continuing legal education courses to maintain your bar membership. If your state requires CLE, we did not apply for CLE accreditation in your state, and your state does not offer CLE reciprocity with Vermont or Pennsylvania, you will need to apply individually with your state bar to receive CLE credit for this course. Some materials that are often requested when applying for CLE, such as the timed agenda, written materials, and faculty biographies, are on the event webpage, so you can find those there. You should have received a link to a form to fill out if you're seeking CLE credit in your email. We will also paste the form in the chat as well. Please wait until the end of the event to fill out this form. The form will ask for your name, your email address, the states in which you're seeking CLE, your bar information, and for a code given out during the webinar. We will be providing you with a code at some point during today's webinar. The code will be sent out in the chat, and we will provide it verbally as well. You'll need to include that code in your Google form in order to verify your participation in the course. After the event, we will verify that all participants who filled out the form were logged into the webinar for the duration of the event and provided accurate CLE codes. After verification, we will provide you with a uniform certificate of attendance via email. These certificates can be used to verify attendance and in many cases can also be used to apply for CLE credit individually in states. Should you have any questions at all about CLE, please email us at our new CLE email address, which is cle@eli.org. On an unrelated note, or on a note unrelated to CLE, we will have time for questions at the end of today's event. Should you have any questions, please pose them in Zoom's Q&A box. You do not need to wait until the end of the program to ask your questions, so please go ahead and ask them in the Q&A box as soon as you think of them. I will now go ahead and hand things over to our fantastic moderator, Christine Perry. Christine is a staff attorney at ELI committed to advancing human rights in the environmental context with a particular focus on gender and disability. She works primarily on international issues with a focus on Latin America. Prior to joining ELI, Christine worked for Amnesty International, International Secretariat's Law and Policy Program. Her work on international human rights focused on the right of persons with disabilities, gender, policy development, and strategic litigation. Christine holds a JD from The Ohio State University Moritz College of Law and a BA in Spanish and Creative Writing from Denison University. She is admitted to practice law in Ohio. I will turn things over to you, Christine, and just want to give everyone a big thank you again for being here today.
Thank you, Madison. And again, thank you everyone for joining us. Thank you to our panelists. Before we kick off, I'd like to introduce the Clearinghouse again, since this is the fifth part of our Community Lawyering for Environmental Justice in the series. And the Clearinghouse is the Environmental Law Pro Bono Clearinghouse. The Clearinghouse accepts viable matters from communities and individuals seeking pro bono legal representation. That ELI does not do any of the vetting ourselves for these matters, but instead individuals, communities are referred by environmental law clinics in general, nonprofits, other attorneys, And once we have the matters, we post them on our website. The clearinghouse is open to both ELI and non-ELI members. In a little bit, I will pop the website for the clearinghouse in the chat. We do hope that you will join us in taking on this really important and meaningful work. And the CLE series that came out of this for community lawyering really helps the attorneys and the clearinghouse members orient themselves for this type of work. That community lawyering is often quite different than the usual work that lawyers might do at a firm or government agency. So we want this series to be interactive, useful for these attorneys as they take on this type of work. For example, we would get a lot of questions about conflicts. So one of our recent series was on conflicts and how you can approach them both from a nonprofit, a firm, and an academic setting. So please do check out our other CLEs that we have available. And without further ado, I would like to get started with today's CLE. And the format's going to run as following, that I'm going to introduce each speaker, and then they'll have 10 minutes to give some information. And then I'll introduce the next speaker, again, 10 minutes, and then our final speaker, and then open it up to questions. As Madison said, please don't wait till the end to ask your questions. I want this to be interactive for you. I want you to get the most out of it that you can. And I will let you know that our first speaker, Nadia, will have to leave at 1 p.m. Eastern. So if you do have questions for her, be sure to ask them before that cutoff. So let's get started with our speakers. I'm so excited for them to be here with us that I think it's going to be a really wonderful panel. Our first speaker is Nadia Ahmed. Nadia B. Ahmed was born in Orlando to immigrant parents from Pakistan and India. She is an associate professor at Barry University School of Law and coordinator of the Environmental and Earth Law Certificate Program. Her research centers on the intersection of energy sitting, the environment, and sustainable development, drawing on international investment law and corporate social responsibility. She serves as a Carey Fellow at the Yale-Jackson School of Global Affairs, Fellow on the American Bar Foundation, Council member of the American Bar Association section on civil rights and social justice, and a member of the academic advisory group for the International Bar Association's section on energy, environment, natural resources, and infrastructure law. She has spent her academic career focusing on frontline communities who are the most vulnerable to energy production. She teaches environmental law, property, and business organizations. She is a co-author of the textbook, Environmental Justice, Law, Policy, and Regulation. Earlier, she is a visiting associate professor at Yale Law School and the inaugural visiting assistant professor of environmental law at Pays Hub Law School. Thank you so much for joining us today, Nadia.
Thank you so much, Christine, for the introduction, and thank you to the Environmental Law Institute for organizing this program. What I wanted to speak about specifically before we hear from our other speakers is about some of the key legislation that is passed relating to environmental justice and the legislation that has been incorporated in existing provisions. And so in looking at that, we're looking to see like how you can have the development of a low carbon energy system, and how to really have a system like that that will promote social equity and justice, and at the same time also look at infrastructure improvements that will also improve not only the quality of life, but also work towards having a clean and healthy environment. And so a lot of this work that has been developing is part of a broader community engagement efforts that have centered the work of local communities and different stakeholders. And we're also starting to see see that how all of this work is going to be developed in a way that centers the concerns of communities of color, as well as those who are poor and marginalized and indigenous communities. The way that we've seen federal as well as state level legislation occurring has been through a very multi-stakeholder approach, but also in a multidisciplinary space. From how we view it as academics, it's not just looking at it from the environmental perspective, but also looking at it from the sense of what is happening on the ground. What are the social impacts? What are the economic impacts? What are the environmental impacts? And so we look to see how we can bring all of these different facets together to have the development and the synthesis of more robust laws that incorporate an environmental justice. And not only are we looking at having clean energy, but also energy efficiency. So we see lower utility bills and also lower water bills, which are very crucial for marginalized communities. There's also this sense of having renewable energy investment, not only in places that are affluent and rich, but also places at the margins. And so this is what the key legislation that has been passed in 2022, it will really be important to do that. And that is also developed through setting up specific types of value change for just energy transitions, and as well as fostering specific types of innovation as well to make that happen. And so then if I can, I wanted to just share my slides. And so some of the key legislation that we've seen coming out includes the Inflation Reduction Act, which was preceded by the bipartisan infrastructure law. And so the changes that you're going to see relating to that is just that we're seeing quite a bit of movement in terms of how the US is going to be able to keep up with its Paris commitments. And so according to research that has also been done by the World Resources Institute, we are seeing as well what the US can do in terms of being able to deliver in terms of having climate finance, but also looking at environmental justice included within that. So the Inflation Reduction Act includes a $370 billion that has been set aside to lower energy costs for families and small businesses, as well as to accelerate energy solutions in every sector of the economy, as well as to work to strengthen supply chains. And as that happens, the goal is to increase good paying jobs and not just to create jobs. And so what was really at the heart of the Inflation Reduction Act was to create the manufacturing within the United States. So not only is that you have a clean energy transition, but it's a just transition. And so these new economic opportunities that are developed as a result of these clean energy initiatives are also going to be possible to create a new economic system. And so we kind of grapple with this idea of what is a just energy transition. And so the Biden-Harris administration has really looked to focus on what it can do for working families. And so the Inflation Reduction Act really works to develop, what are specific types of clean energy incentives. And one of the part of that is also includes this idea of the president's Justice 30 initiative, which has sought to deliver over 40% of the overall benefits of climate, clean energy, and federal investments to communities that are marginalized, overburdened by pollution, as well as underserved by infrastructure and other basic services. And so we're also looking to see exactly how the Inflation Reduction Act is going to, build off what has already been put in place. And so the U.S. has really sought to reduce its greenhouse gas emissions below its 2005 levels so that it can reach that point by 2030. And so what the IRA, which is more commonly referred to, is also a combination of the bipartisan infrastructure law. And so between those two pieces of legislation, the Department of Energy estimates that there's going to be at least a 40% reduction in economy-wide greenhouse gas emissions below those 2005 levels to reach that in 2030. And so for me, like, I was really amazed to see that happening, and it happened so quickly. But part of that should not be so astounding, because during the pandemic, we saw the passage of $1 trillion, $2 trillion aid packages to prevent us from annihilation as a species during the pandemic. And so that is also the type of commitment and the Herculean efforts that will be required going forward for especially having climate change adaptation and clean energy in a way that doesn't leave environmental justice communities behind. And so what the Inflation Reduction Act also has done is to include provisions to include also electric vehicle charging stations, power infrastructure, as well as climate resilience. And so a lot of this is about creating the mechanisms that are going to drive change, especially about having clean energy options. And so how those specific tax credits are going to be deployed and are also happening on different levels. So whether it is for solar panels, for wind turbines, batteries, as well as critical minerals, that is going to, the legislation is going to provide about $30 billion to that, which is going to also have another $10 billion for clean energy tax credits for manufacturing. And of that, about $6 billion is set up for existing heavy manufacturing, such as steel and cement. So all of those supply chains are really trying to be a part of what is happening. And there's also going to be an incentive program, which has had some controversy relating to clean hydrogen production, but it's also seeing that there's been movements away from coal as an economic driver, especially for communities which have been disenfranchised and have been left out of the clean energy transition. So being able to provide direct incentives to those who are able to decarbonize their homes, as well as to create clean energy jobs is really has been very, very crucial. And there's also been $8 billion that was allocated as well relating to financial and technical assistance for clean energy projects that are going to benefit low-income communities as well as disadvantaged communities. There has also been about $12 billion that has been allocated for direct and indirect investments for renewable energy projects. And so this really builds off of the earlier legislation that had passed in 2022, which is the bipartisan infrastructure law, which is really seeking to strengthen the nation's resilience, especially in response to extreme weather and climate change. For me, I'm based in Orlando, Florida. Last year, we saw two very extreme weather events with Hurricane Ian and Hurricane Irma, and the impacts of them are similar to very extreme weather that we had seen in 2004. But what was really astounding is that the sea level had increased over a foot in that time period, in those almost 20 years. And so as a result of that, the impact of the storms was far more intense, and the water is taking far longer to recede. There are communities that are still flooded and are not going to be able to go back to the way they were previously. And so this is really building upon President Biden's larger movement towards the Build Back Better infrastructure framework. And so this is also really worked to develop how the U.S. is going to be 100% carbon free or having 100% carbon pollution free power sectors by 2035 and achieve a net zero economy by 2050. And some of those provisions include clean water, clean drinking water. So there's over 6 to 10 million lead service lines in cities and towns across the country, many of which are in communities of color and low income neighborhoods. And the bipartisan infrastructure law is seeking to expand clean drinking water. And so this is really what's near and dear to my heart, is that between the bipartisan infrastructure law and the Inflation Reduction Act, there's an aim and desire within 10 years to eradicate lead poisoning from water lines in this country. And that is really the result of movement building that has happened and developed. And what we're also seeing is an emphasis on an aim on legacy pollution. More than 1 in 4 Black and Hispanic Americans live within 3 miles of a Superfund site, and that's a higher percentage than Americans overall. And so no community deserves to live in contamination where they live, work, play, and go to school. And so the bipartisan infrastructure law delivers a wider net in terms of tackling legacy pollution in American history by being able to provide funding for Superfund and brownfield sites, and also reclaiming abandoned mine land, as well as capping orphaned oil and gas wells. There has also been about $21 billion that has been set aside to clean up Superfund and brownfield sites and to reclaim abandoned mine land. And so all of this is part of this broader effort. And so the next part of the bipartisan infrastructure law includes the idea of public transport. And so this also includes concerns about how bus and transit workers constitute about 31% from the African American community and 19% from the Hispanic community, compared to 12 to 18% of the overall workforce. And so this legislation is really aiming to expand public transit and also make it the largest investment in passenger rail since the creation of Amtrak. There has also been an emphasis on clean school buses. More than 25 million school children and thousands of bus drivers breathe polluted air on their rides to and from school. And so this legislation is really aiming to tackle that issue, so that there's also not only having a cleaner air, but also a demand for American-made batteries and vehicles that will also work to create jobs and provide for domestic manufacturing. There is also an emphasis particularly on modern and clean infrastructure and how that's going to be developed with an investment of over $17 billion for port infrastructure and $25 billion for airports to address repairs and maintenance backlogs, as well as to reduce congestion and emissions near airports. And then the broader goal in terms of having resilience is that there will be efforts in terms of how millions of Americans are going to be feeling the impacts of climate change each year, when roads are washed out, as we saw during the recent hurricanes, or when airport power goes down and schools are flooded. And people of color are more likely to live in those areas that are vulnerable to such flooding and other climate change related weather impacts. And so the laws that are able to make our community safer, as well as our infrastructure more resilient, are really crucial. And so there is an investment of over $50 billion to protect against droughts, heat waves, wildfires, and floods, in addition to broader investments for the weatherization of American homes. And so as we see these efforts and how they're going to be developed, it's part of very crucial to see how they're working forward. And so with that, I think I've gone over time, but I'm just going to yield the remainder. Thank you.
Thank you so much, Nadia. I know we have some questions for you when it comes time for that. So I'm excited to dig into those. And I will be now introducing our next speaker. We're very pleased to be joined by Stacey Halliday. Stacey Halliday is a shareholder at the environmental law firm of Beveridge and Diamond PC. She co-chairs the firm's environmental justice practice and is the current chair of the firm's diversity, equity, and inclusion committee. Stacey advises clients on a broad array of issues at the intersection of environmental compliance, ESG, and sustainability, including effectively and efficiently incorporating environmental justice in their work, including as part of their overall ESG program, risk assessment process, or in pursuit of federal funding opportunities, strategically navigating voluntary ESG reporting and sustainability, mitigating risk in corporate environmental marketing claims, and addressing emerging right to repair requirements. Stacy previously served as special counsel to the U.S. Environmental Protection Agency's general counsel from 2015 to 17, where her portfolio included congressional oversight and external stakeholder engagement. And she currently serves as a board member for the Environmental Law Institute. She's a proud graduate of Howard University School of Law and Harvard College. Thank you so much for joining us today, Stacy.
Thank you so much, Christine, and thanks to the Clearinghouse, to ELI, and to co-panelists for this great opportunity to have this conversation. As Christine mentioned, I think my perspective and contribution to this conversation is really thinking about where there are opportunities, and thinking about the community lawyering context, where opportunities are sort of created now that there's sort of a stronger business case, arguably, for incorporating EJ. So as Christine mentioned, I counsel clients on incorporating EJ into their work, and it really has fallen into a couple of different buckets of increasing variation as this landscape has evolved. First, sort of at the company-wide level, it's looking at risk assessments, tracking regulatory developments, compliance obligations, and enforcement risks. So that could be something like mapping all facilities and getting an assessment of not just federal policy shifts, but also state-specific jurisdictional requirements for those facilities. As the other sort of company-wide work that I do focuses on ESG and EJ governance counseling. So things like developing an EJ policy, creating implementation strategies for different aspects of the company's work, and then developing training programs, because a lot of these companies, EJ's been around for decades, but a lot of C-suites haven't been familiar with this term. And now everyone's really eager to figure out, what does EJ mean? What does it mean for us? How do we think about it for our company? More limited scope work, more advising clients on federal funding opportunities. So all of what Nadia was talking about, IRA and IIJA grants, there's a huge driver now for companies to be thinking about EJ in the context of being competitive for those grants. So that's a lot of what we're doing. And then finally, there's the sort of traditional work of more project or permit specific counseling as permitting authorities start to ask questions about impacts on neighboring communities. So it's been really fantastic getting to do this work, and never thought I'd be doing it in the private sector. So it's really exciting to see it grow. As I mentioned, there's a really strong growing business case for consideration of EJ. I think building off of sort of the regulatory and the legal landscape that Nadia painted, so that mitigation of enforcement risks, really, we're seeing out of agencies, particularly like EPA, a clear focus on prioritizing enforcement action in communities facing environmental justice issues, including an uptick in Title VI enforcement. Title VI of the Civil Rights Act, which prohibits discriminatory use of federal funding, to put it simply, on the basis of race, color, and national origin. So we're seeing a really pretty potent increase in investigations and overall activity in Title VI for federal funding recipients, which raises an interesting question about what that means for all the IRA money and IIJA money now going to a lot of private companies who are now going to be federal funding recipients held to the same civil rights laws. So that's a fun conversation a lot of clients are now asking a lot about, and they want to get ahead of it. There's increased, as I mentioned, permitting a lot of different agencies now because of Executive Order 14,008, which directed federal agencies, sort of reiterated the Executive Order 12898 directive from 1994 to have federal agencies consider environmental justice in their work. Executive Order 14,008 made that a much more granular requirement and incorporated a lot more accountability in terms of demonstrating that commitment incorporation. So including the Justice 40 program that Nadia mentioned. So we're seeing a lot of agencies interpret that those marching orders differently. So agencies like the Army Corps of Engineers, which oversees Section 404 permits of the Clean Water Act, they're thinking about, how do we think about the NEPA process? How do we think about impacts on community, on neighboring communities with respect to permitting? How do we quantify those impacts? How do we document them? And how do we weigh them against other countervailing benefits or other issues that we're considering with respect to permitting? So again, clients are trying to get ahead of that and understand how they measure those impacts in a way that is meaningful and effective and makes sense for their operations. We're also seeing a lot of interest from investors, increasingly so from activist investors who are, during the proxy season, demanding racial equity and environmental justice audits. It seems like that's a lot of that activity moves towards settlement activity. So it's not necessarily something that results in an environmental justice audit, which could be something like, we want to see you document, how do you document and assess your impacts on communities? But it's turning more into sort of an action forcing gradual change in companies to not necessarily get to the full audit, but to start to look at these issues and to start to think about a policy or start to think about impacts in a meaningful way. And then finally, I mentioned again the competitive federal funding piece, which is just so dynamic. A lot of these, particularly DOE funding opportunities, require incorporation of a community benefits plan in the application process. And that could include anything like how a proposal for how the applicant is going to include things like workforce development, community engagement, diversity, equity, inclusion, and accessibility in their work, and then also what Justice 40 metrics they're going to use to track their work phase over phase of a project. And that funding can be conditioned in an iterative way on that performance. So it's a pretty big deal, especially for companies that are trying to be competitive in this space and don't have a robust EJ program or ESG program or engagement efforts. So it's sort of driving, I'm almost seeing more change in my work on that side of the sort of funding, the carrot aspect as opposed to the stick, because these companies are saying, really, we want to be competitive, we want to get these funds, we want to contribute in the energy transition. So they're sort of being driven to develop these programs in a pretty significant way. So I think these opportunities that I've noted really are coming from the perspective of business, but when you think about the community counseling and the community lawyering angle here and opportunities through groups like the Pro Bono Clearinghouse, I think these industry focused opportunities really do also create some really important community learning, community advocacy and community lawyering opportunities as well. More and more often, communities are going to be proactively engaged by industry and by government, not just when something goes wrong. And community lawyering outfits like the Pro Bono Clearinghouse can really provide helpful resources and technical assistance so that communities are prepared for the opportunities and can really use them effectively. So things like assistance with understanding requirements, particularly for community engagement, looking at New York and New Jersey with their permitting, the new EJ permitting laws that require consideration of cumulative effects in permitting decisions. Massachusetts has their new proposed rule on cumulative effects assessment, and Pennsylvania has guidance on expanded community engagement requirements. So helping clients and communities understand where they can play a role in the process in a meaningful way, and understanding how to articulate meaningfully what the impacts are on them and how to advance their own interests. Because I remember working at EPA, I helped the agency respond to the Flint drinking water crisis, and these communities often, as we all know, face not just one, but a variety of ills from just from long-term challenges. So it's hard sometimes to take these opportunities and make meaningful progress from them because there's so many things to take apart and put into a context that can make sense in a legal proceeding. So that technical assistance, I think, is really helpful. I think effective engagement and input with federal agencies. So EPA is increasingly hosting comment sessions targeting communities facing EJ concerns. This presents really important opportunities in the rulemaking process. There's going to be probably a lot more of that with the Office of Environmental Justice and External Civil Rights. I'm getting used to the new acronym. And I'm sure that they have a Journey to Justice initiatives at EPA. There's going to be a whole lot more of this engagement. So having effective counsel and support to take advantage of those opportunities, I think, would be really helpful. And then finally, navigating these industry partnerships. I mean, the CBA, the community benefits agreements through these community benefits plans for things like DOE applications. It's huge. You can get some really great benefits if you know what to ask for and how to ask for it, and that there's enough consensus prior to those opportunities coming up. So that's sort of I think it's going to feed into the Justice 40 definition of benefits too, that are specific to communities. So helping communities understand and define benefits in that framework of Justice 40, I think will also be a great opportunity for community lawyers to make an impact. But that's all I had. I'll pass the mic back to you, Christine.
Thank you so much, Stacey. I know we have a lot of questions for you too. So I'm excited. And yes, please, everyone, please keep sharing your questions in the chat. We will try to get to everything. And our final speaker is Christy Hicks. And Christy Hicks is a Senior Director and Lead Counsel of Equitable Regulatory Solutions at the Environmental Defense Fund. And Christy leads EDF's strategy to co-create a durable new model that prioritizes equity in the energy transition. She focuses on regulatory reforms that equitably reduce our reliance on fossil fuels, eliminate overinvestment in long-lived fossil fuel infrastructure, increase clean energy access, and advance energy justice. Christy has a JD from Loyola University Chicago School of Law and a BA in Criminal Justice from St. Louis University in St. Louis, Missouri. And before we jump into Christy's, I do want to say on the worksheet under Christy's section that there's a slight edit to the 4 types of equity. And we'll be now using procedural justice, recognitional justice, distributional justice, and restorative justice and intergenerational equity. So when you are filling out your worksheet, please take note of that. And Christy, now over to you.
Thanks so much, Christine, and thank you to the Environmental Law Institute for the invitation to speak today. I have really enjoyed this series thus far, so it was a real honor to be asked to participate, and I've already learned so much from my fellow panelists today, and hope to continue learning and have a conversation after we finish sort of our opening remarks here. So really looking forward to that discussion. As Christine said, I am a Senior Director at Environmental Defense Fund for what we call Equitable Regulatory Solutions. What that means is that my practice is focused primarily before state public utility commissions, and I also oversee a body of work before other federal energy regulators and state regulators across the country that have some authority or decision-making over energy infrastructure, programs, siting, etc. And I have a really deep focus in my work energy justice, and I work very closely with many community-based organizations. That's work that had been ongoing before all of the new federal regulations came into play. And in large part, that's because many of our states were probably a little bit further along than where the federal government has been. And I think there's a lot of really important lessons that we can learn from state and local work that has been going on now for years, and often cases, decades, actually. We have many community-based organizations who have been at this for many, many years. And so we don't need to reinvent the wheel here. There's a lot of great lessons that we can learn. I was asked to talk about how communities can leverage the new laws and regulations and what decisions have been left up to agencies and how they can implement those statutes meaningfully. So I'm excited to talk about the intersections of the work that we've already been doing at the state and local level and how we can use that to develop best practices and improve the way that we implement all these new statutes and regulations. So as we know, there are many decisions that are made up or that are being left up to implementing agencies, billions of dollars, many new programs, and the work is underway right now. The comment processes for several things, some have even closed already, some are ongoing right now. There's grant dollars going out the door, and a lot of the decisions are being made on that right now. And these are the kinds of things that are going to set the course for whether these new programs and requirements are actually achieving the goals that they were set out to achieve. The opportunity to get that right is yesterday. My point here being that we have to work really hard to get it right from the start and not fall into the decisions are being made right now, so we will just work as quickly as we can. That's what has led us to where we are today, and that will truly just perpetuate the inequities of our energy system and the environmental injustices that we see that have overburdened communities that have nowhere left to give. So while these requirements and the dollars and the programs are a great start, that is only the start. And in my humble opinion, implementation is equally, if not more important for truly addressing the deeply entrenched environmental racism and environmental injustices that exist today. It's going to require whole systems change. The new foundation on which we can get that right, or we can perpetuate those inequities, is going to be new processes, new ways of working with and for disproportionately burdened communities, and new ways of thinking for many decision makers and many stakeholders. And for that, there are so many parallels and intersections with our state and local work, including supporting meaningful participation by communities and community representatives. And organizations like mine, our role isn't to be a stand-in for frontline communities or to represent their concerns. We are not the experts on what they want or need, but we can and we should leverage our regulatory and our legal and our technical expertise to raise the voices of frontline communities and to assist those organizations that represent those communities to have a seat at the table. That also requires acknowledging that these are usually not single issue organizations, like so many of us practitioners have that benefit, and to recognize that they have capacity limitations and they have daily disproportionate burdens of health and economic and environmental and so many other injustices that they are all juggling. So one of the key ways to think about the new legislation and regulations in my mind is really from the outset thinking about the high barriers to participation that have excluded those communities and those organizations from being involved in previous decision-making processes, and that have really limited that to only well-resourced and sophisticated participants being in those decision-making spaces, so that the new ways of decision-making are truly foundationally different. The reliance on what some call epistemic authorities, got a lot of letters after your name, is what has led us to where we are today. So we have to listen to different authorities if we want to see different results. And it's really important that we as practitioners be intentional about that and take the time to do it. And it does take more time to support community members' priorities rather than moving forward with what we think is the quickest and what's, quote, best for them way, and then coming in later and trying to get community buy-in rather than having had authentic community engagement from the start. So a few high-level questions that I ask myself in this work that's really informed by the environmental justice and community-based organizations that I work with in this space. For each program, for each investment, for each requirement, thinking about a few different questions. First, is this what the impacted community wants, and how do we know that? Who stands to benefit and who stands to be harmed? What are the costs? Who pays them? And what are the potential cost savings, if that's applicable? Are there any alternatives, and have the costs and job opportunities and other societal impacts of those been considered? And then, as Christine was laying out at the outset a little bit here, thinking about the different types of equity. Is there procedural equity, that is how the decisions are being made, both in the actual proposal and in the process for making a decision about it? Is there distributional equity in the benefits and the burdens of whatever this decision is going to be it a grant, be it a new program, be it awarding something to a particular institution? Are there structural and intergenerational equity questions that haven't yet been thought about? The long-term positive outcomes, the institutional accountability, and is there recognitional equity, meaning acknowledging the disproportionate burdens and disparities in social vulnerability and having the right voices at the table. I think it's really important that we be explicit and not implicit about any of those. We have to name those questions, and we as stakeholders and as informed practitioners who have the luxury of spending our time in the legal space here should expressly describe how we are thinking about each of these things, and we should encourage and seek requirements for decision makers, whether it's a decision about a legal case or a particular grant, to expressly describe how they considered community perspectives in making their decisions about that. And we can and we should seek out communities and organizations that don't know how and where to engage, so that we can think about what support we can provide to them if they want to get involved. What are the gaps and how can we help to fill those? And for those who maybe, aren't in a position to, go into the clearinghouse and find cases and opportunities to represent others, or don't work for an organization like mine where there's not opportunities for direct collaboration with impacted communities, at least, as I said, thinking about how we can avoid the traps of community buy-in, or thinking about what's community as opposed to authentic community engagement, which is really the only way to get this right. And I'm excited to talk, I think, a little bit later here about some specific examples of ways that I have worked with community-based organizations in contexts that I think are directly applicable to how Justice 40 can be implemented, to how grant making can be thought about, and addressing the historic exclusion of impacted communities in those kinds of decisions. But again, just want to really thank my fellow panelists and thank ELI for having me here this morning, and looking forward to digging in more.
Thank you so much, Christy. And I am going to say that a big thank you to Nadia, who has to leave us just in a few minutes. So Nadia, if you have any brief closing remarks you'd like to say before you have to go.
Thank you so much. The one thing I was going to add is there was a question that was in the Q&A session that I had responded to it already, was about how does the Justice 40 initiative relate to the IRA from a funding perspective? So I had dropped in a link to the list of agencies that have already started to cover this, and so I think this is really remarkable. But at the same time, like Christy just pointed out, is like there's gaps in terms of the implementation of it, and so that's why I think it's really crucial, especially for environmental professionals, to uplift communities at the margins, to make sure that they recognize and are available and know of these resources and how to obtain and leverage them. And so I just wanted to highlight that. I already answered a question within there, but I can. It's a link to the White House's Environmental Justice 40 initiative, and how it's going to expand quite rapidly in the coming years. And I think being able to understand like the scope and breadth of it is very, very important. So thank you.
Thank you, Nadia. And Nadia graciously has given me her email if there are any follow-up questions, so we can share that as well. So again, thank you so much, Nadia, for joining us. And we have a lot of people asking questions in the chat, so that's wonderful. So please, we're going to do our best to get to all of the questions. And if we don't get to your question, I am sorry, but we are going to do our best. So I'm going to start with one for Stacy. Stacy, can you say more on what the Army Corps is doing on NEPA and environmental justice? Is this a specific rulemaking, or is there a development of guidance?
Sure. Sorry, I just discovered the Q&A and it's a treasure trove. But yeah, thanks for that great question. I think what's interesting is the Army Corps is doing what I think also EPA is doing a lot of, which is interpreting their existing authority to incorporate environmental justice and incorporate ideas of equity. So with the Corps, I think what they're doing as part of the permitting process is asking more about how do you document impacts on EJ communities when we're thinking broadly about impacts, particular permitting action. And I think there's a lot of pressure, given the heightened Title VI activity, to make sure that these impacts are being considered, that equity and avoiding potentially having a disproportionate impact on vulnerable communities, making sure that's avoided and considered at the earliest possible stage. So there's a little bit of fear, I think, and anxiety in these agencies who don't want to be targeted in that particular way by Title VI. So I think it's having that kind of potential outcome. But also, I think a great tool in this respect is also, this is such a geeky Office of General Counsel thing to celebrate, but EPA's legal tools and their addendum for cumulative effects, it's really cumulative impacts. It's a really nice, I think it might have been torturous for all the OGC lawyers to put that together, because it's so dense and it goes statute by statute to say where can EPA and its programs incorporate environmental justice under existing authority. But that's sort of a map of, I think, what we're seeing happen in a lot of agencies where they're having to do that analysis. And it's not a new EJ law, it's not a new rule or explicit mention of EJ, but it shows how it can be woven into regular day-to-day agency work, like what we're seeing from the Army Corps as well.
Thank you. So I'm really just going to jump around with these questions. Okay, there's one. Do either of you know of any, or can you point the audience to any digestible resources that are helpful to provide community leaders regarding how to effectively leverage their voices, as corporations and governments now have a higher incentive to engage meaningfully with them?
I can start and say that I think from my perspective, part of what brings us here today is that the burden shouldn't be on overstretched community-based organizations to have to put in all that work on their own, and that I hope that those who are on this call and the others within our networks can leverage the expertise and the resources that we have to partner with them and to lift up their voices. It seems just a further burden to expect communities to go out and do that on their own. So it's a great question, and I think there are actually so many local organizations across the country who have already been doing a lot of great work, and it's probably a little bit less visible if you're not deeply entrenched within their networks already. But looking to community-based and environmental justice organizations in your neck of the woods and seeing all the great work that they have already done, rather than looking for maybe one particular omnibus resource, is a really great place to start.
I couldn't agree more with Christy's point there. I think so much of this is local and state by state. Like SEHA has a great document that I've looked at forever. I think it's the California Environmental Justice Alliance. I'm forgetting the A, but CEJA. And they've had a resource that I've used forever and loved in terms of just thinking about community engagement. It's effective and it's targeted towards communities and taking advantage of some of the California specific laws that empower and elevate communities. So I'm sure we'll see a lot of that out of New Jersey, but every different jurisdiction, especially now, is pretty nuanced and different. So I agree that we should use more localized resources. There's some really strong ones coming up these days. Although I imagine also that there's probably some good reception too at the federal agency level too, and EPA. I imagine right now everybody wants to answer the phone for communities right now, I would think. But I agree with Christy, it shouldn't be the burden on the communities, but I think if there is a desire and appetite for that, and reaching out to an EPA region or a local EJ group is a great resource.
Thank you both. Next question is, any indication of EJ cases that might be put in front of the Supreme Court that would impact or hinder this new legislation? If you had a crystal ball.
I think there's going to be some interesting, the affirmative action case with, was it Harvard and UNC, should have some interesting implications for Title VI in terms of how we think about discrimination and implementation of those laws, and if that's going to impact the way that funding is distributed and how we think about benefits, and it's just a big thorny. I stay up at night thinking about this and haven't completely gotten through my what I think is ahead, but that's something that comes to mind in terms of what's currently before the court. I think oral arguments already occurred, so we're just waiting on the decision.
Yeah, I absolutely agree. And I think maybe some high level context for those who aren't as deeply embedded with environmental justice communities. There was some concern within EJ organizations about justice and the ways in which certain communities were or weren't going to be designated as the communities that were targeted for that. And I don't think that discussion is over. From the federal government's perspective, they are working within the confines of the Constitution and had to use neutral qualifications for which communities would be designated as those for which, it says my internet connection is unstable. Am I here? Okay.
I can still hear you and see you.
There's been so much civil rights work already that has been around race neutral versus race conscious legislation and regulations, and there are state level equivalents for Justice 40 that are dealing with these same things. I'm in Chicago, Illinois. We have what's called equity investment eligible communities, which is also a race neutral categorization or designation for certain environmental justice and overburdened communities. And we also have requirements for disparity studies that will begin soon. And I think there's going to be equivalents for those on the federal level as well, because there are exceptions within the case law that if you can show these very specific kinds of disparities, then it is okay to use race conscious language. But then, the cases, for example, that Stacy was just discussing have the opportunity to possibly upend all of that. So it's going to be very closely entwined with that civil rights body of law as we're looking for how we're implementing these environmental justice provisions of the law.
That was great, Christy. Thank you. I was just like, by the way, Title VI, Supreme Court, affirmative action. I'm good.
I was just making the connection there.
Yep, no, that was good. Thank you.
All right, this one is for Christy. Specifically, Christy, in your presentation, you had a list of questions and prompts that was very helpful, starting with, is this what the affected community wants? And how do we know that? And could you maybe drop those in the chat, those questions or prompts, because people are eager to have those in their work, which is great.
I am happy with the caveat that I am very much on a learning journey myself, and these are some really high level questions that I use today in my work. There is no magic to them, and I encourage everyone to use whatever body of questions works in for them, and to please let me know if you think that I'm missing really big important things that should be on the list.
Thank you. And all right, so the question around the IRA and Justice 40 initiative was really about, is the IRA funding justice? Is it funding the Justice 40 initiative? What is the relationship there?
Well, no, it's less about funding, and I'll drop. Sorry, folks asked about the Supreme Court cases, and I'll drop the link for that stuff in the chat. But it's Justice 40 is a commitment from EO 14008 to direct 40% of benefits from climate investments to disadvantaged communities. So I think it's currently being sort of as defined by CEQ's CGIS tool. That seems to be the main focal point for defining those communities. And as Kristen mentioned, is currently race neutral. So with respect to the IRA, at least from my perspective with the CBP work that we're doing, applicants are being asked to provide metrics to demonstrate that those benefits are flowing to identified DACs, disadvantaged communities. So that's one thing. It's really more about measurement of the distribution of those benefits and impacts. It's less about direct funding for the program itself. So all federal agencies, federal funding agencies with applicable programs, and there are Justice 40 applicable programs, so a list of them, that identify which programs are being tracked to reach that 40% federal family-wide goal. So that's really the challenge here. Is I think one of the questions in the Q&A is really, how do you define benefits? How do you define DACs? How do you do that in a way that makes sense, that is defensible and lasting and all that? So I think the benefits conversation is still one that's still evolving. I think DACs have sort of settled into the mapping system, and that's going to be challenged, but I think we're really more in the conversation about how we're defining and tracking those benefits in an effective way and deciding if they're actually flowing to those DACs.
Thank you. And Christy, I don't know if you want to jump in on the definition of benefits conversation. How do we really define that? How do you see it being defined in your work?
Yeah, it's a great question because it's one that we are still figuring out. And I think there's likely not a one-size-fits-all approach depending on what the particular program or investment is. One example that I can give from my work is that, as I said, I'm in Illinois, and we passed in 2021 what was called the Climate and Equitable Jobs Act. And it included a Justice 40 equivalent requirement, particularly for electric distribution grid planning, that at least 40% of the benefits of new grid investments must accrue to, as I said, they're called equity investment eligible communities. And so we took a step back and took on what I called the Community Experts Project, or Experts Next Door. And it really was with the hope that we would have lived experience testimony that would help to shape how the decision makers were deciding what it meant for the benefits to be accruing to the communities that they were intended to reach. And over the course of the last year and a half or so, have worked with a number of community representatives to introduce their lived experience and their community representative testimony at our State Public Utility Commission. One particular example that I think maybe is helpful because it's really tangible here is that there was a community member who talked about the house that she lives in today. She's a septuagenarian, lives in the same house where she grew up. And she talked about the fact that as she was growing up in that home and in that community, it didn't require air conditioning. It was a really vibrant community. There were a lot of services around. It was just a really great place to live and to thrive. And there have been a lot of changes over the 70 years that she has lived there, including that her area has become an urban heat island. There's far less tree canopy. There's far more pollution. Over the course of her 70 years, there have been industrial facilities that have gone in, that have come back out again, and there's been a lot of disinvestment in her particular community. And she talked about how that impacts her in her daily life, the other cumulative burdens that she and her community deal with. And then we had a technical expert who evaluated, what some of the data that we can crunch that can show what these disparities are. And one of the things that we looked into was how frequently she and her community experienced electric service outages because of the multitude of ways in which that impacts their quality of life. And discovered just a couple of quick hit examples here that are particularly jarring. That in the city of Chicago, equity investment eligible communities experience outages over 80% more frequently than non-equity investment eligible communities within Chicago. They are almost 12 times more likely to have 4 or more outages in a year. Their outages are 140% and they are more than 4 times more likely to have outages that last 12 hours or longer. And the investments that the energy companies proposed to address that was, well, we will improve our territory-wide service. And because of the testimony that this community member had given, and the data she was able to help our technical expert to put in, then the decision makers said, no, what we really need to look at here is the disparity, not just what improvements can be made, but whether we're closing the gap here. And it was a very different way of looking at the problem. And I think that being very intentional about looking at disparities when we're thinking about Justice 40 investments and how those benefits are accruing is that a benefit isn't necessarily just, okay, $1 million goes to this community. How is that $1 million spent? And does that $1 million address a disparity, or is it just going to be $1 million that goes to maybe some of the same kinds of investments that companies or the government would have been making otherwise? So that's kind of a long-winded way of getting to that point, but I think that having the concrete example is helpful. I hope so.
No, that's very helpful. I mean, because it can be such an abstract, what does it mean? So that I think was very illuminating. Thank you. Another question has to deal with these grants, and how do you see the role of scientists and engineer and academia and industry in working with community lawyers to take advantage of these grants? And this can be for anyone.
Yeah, I mean, I think it's a pretty, the projects I'm working on tend to be pretty significant. I mean, there's a lot of funding, and there's the creation of these sort of hub-focused activities that try to put together sort of clean energy generation with end users. And so you've got that whole sort of life cycle, including engagement with communities. So I think, that's one of the perks of doing this work and being in environmental law is that you get to work with scientists and technical experts so much of the time. And I think that really helps with thinking about, a lot of these applicants are being asked to really understand what the impacts of their work are. I think in that very broad-based way that Christy just characterized, and having technical experts available to help think through alternatives, to think through mitigation strategies, to really understand the full scope and capability of whatever the technology is, I think is really, there's so many emerging technologies right now that tend to mitigate any adverse impacts and also more broadly achieve clean energy solutions. I think having those scientists on hand with the lawyers, with communities, can really help to understand what are the impacts, how do we make increased benefits, as well as mitigate any harm in a way that lawyers certainly can't.
And Christy, sorry, I'm going to take that further. In your work, are you working with, I know that you are working with a large coalition of experts. Do this involve engineers, scientists, non-legal experts?
Yeah, all of the above. One thing that has been really impactful, I think, in, again, thinking sort of about this foundation, our ways of working, is having community listening sessions and having the technical experts coming and participating, and having a dual role of both, providing digestible, sort of translated information of, what is happening here, why it matters to a community, and what opportunities there are for them to be engaged, and then just listening. And I mean that very deeply for myself as well. We do not know what's best for a community. And so providing information so that they can make those decisions for themselves, and then having a really authentic feedback loop of, here's how I see that, these priorities that you have just lifted up, translating to what we're working on right now. What do you think of that? And making it a really iterative process has been just really transformative in the work, and just really fun too. I mean, the opportunity to have engineers and economists, sitting down with community members and, just talking about each of our experiences. It's so the relational aspect of it is just as important. Again, so the how we work being transformative for the ultimate outcomes, I think.
Thank you. And we might have time for just a few more questions. And this one is for Stacy. And there are some acronyms in here, so bear with me. Do we expect that the OEJ ECR IRA funding will overlap with the Department of Energy grant funding for industry? Where did that go? Sorry, it's moving around. For industry commitments laid out in their Justice 40 initiative plan?
That's such an interesting question. I think agency alignment is something that is so hard right now because there is so much pressure to deliver and so much more accountability on agencies to show their EJ chops. And Justice 40 puts a finer point on that with actually documenting it and showing where the money's going and showing that furthers those goals. I do think there will be some probably necessary overlap. A lot of these projects are looking at the same sort of urban areas. They're looking at the same, not necessarily urban areas, but sort of identified DACs that are feasible and make sense with whatever the targeted goal of the funding is. So I do think there will just be some overlap by virtue of that. There's a universe of DACs. They're focusing on those DACs. I do feel like the EPA funding from, I've seen some of those emails come across the wire, is more focused on community technical assistance and sort of capacity building, whereas the DOE funding is more focused on particular energy solutions with a substantial community engagement component as part of those projects. So I think they're sort of targeted in different ways, but will ultimately have some overlap just by virtue of the sort of closed universe of DACs.
Thank you. And for both of you, are there public resources that you would recommend that shows the allocation of funds and their direct impacts to address disparities within the EJ communities?
I'm not sure I'm understanding exactly what they're looking for there, but for example, when the Inflation Reduction Act was passed, from the White House that had the specific lists of which programs were intended to address environmental injustices. And I know there's different organizations who are tracking the implementation of different parts of that. So I think it is probably somewhat dependent on specifically which kinds of programs someone is interested in. And then there's probably a trade association that has some kind of tracker going on their website that you could look to.
I'm sure they have all kinds of tools. Yeah, I think some agencies are also, I think it's pretty early in the process with the IRA and for Justice 40, and there's probably some light reluctance to get everything off the ground, but a lot of those programs, the grants have timelines that go out years, and the first stage is usually a planning stage. So seeing that all play out is probably going to be a couple of years from now, and it'll be interesting to see a changing changing political landscape and those programs play out in real time. But there are some agencies that are trying to make public how their investments in environmental justice are benefiting communities through their sort of report outs on EJ progress. EPA does sort of, I don't know if it's quarterly or it might be annually. I think it might be annually. And they list sort of environmental justice investments, progress, enforcement, whatnot. DOE has a dashboard. I think it's called the Energy Justice Dashboard, and identifies investments that are made in DACs. And it tells you what the grant number is and what the actual project was, but it's not granular in that it shows at least that with my amateur use of the dashboard, all I can see is the total amount in the project itself. And I'm sure there's ways to drill down further on that, but they've probably got the best resource I can think of right now about distributed funding and where it's going and for what purpose.
Thank you. So we'll all meet back here in 5 years and we'll revisit that question. The next question, well, maybe less time, but that is something to keep in mind and will be interesting to see how that plays out. I think this is important, Christy, to bring up to clarify what you said about the distinction between traditional authorities with letters after their names and the need for different authorities. And can you expand upon what you mean in defining traditional and who would be the new authorities?
Yeah, so the question a few minutes ago, I define traditional authorities as engineers, economists, PhDs of all sorts, and including a lot of the stakeholders who have been playing in these spaces for many years, if not decades, and thinking about things in really similar ways. So, for example, so much of this work, there are cost-benefit analyses or cost-effectiveness tests, and those have been happening in similar kinds of ways for a really long time. But community members have information, they have expertise that can't be shown on a map. It doesn't appear in any kind of a data set. They have the lived experience and the expertise on the way that their community has evolved and on what their community needs and what their priorities are that aren't going to be understood or reflected in traditional data. So in my view, thinking about stories as an expertise of their own is a really important new way of working. And there are so many representatives of community-based organizations, as I was saying earlier, who have been so deeply entrenched in this work for decades before any of this legislation was passed. And by simply supporting their priorities through the expertise and the resources that we have, we can promote that expertise and work directly with community members and representatives within their organizations and use our legal expertise to define them as experts. And there is an important place for lay testimony and lay comments in a lot of these spaces as well. But particularly once you get to the legal phase of things, decision makers are oftentimes bound by the record of the particular proceeding or decision that they are looking at right then. So if that community expertise isn't a part of the record, then there's only so much that a decision maker can do. So looking at who are the ultimate decision makers going to be and what is the body of evidence or data on which they'll be making their decision, and thinking of some out-of-the-box ways that community representatives and community perspectives can be represented in the materials on which they will make their decisions is, I think, a challenge for all of us who have been, blessed to work in this space, and something that our agencies and our implementers have to be thinking about as well.
Thank you. And I think time for one more question before we go to closing remarks. And this is really for more concrete examples for both of you of who have you seen, how have you seen these regulations, legislation incorporated into direct action by community groups, industries?
I mean, I've seen a whole host of things in the last couple of years, especially from, companies who were clients who were waiting for an opportunity to have a really strong business case for their boards, for their C-suite, to say environmental justice is really a material issue for our company and for long-term value generation. Like, that's now with clear directive from the federal government, from commitment on enforcement, on funding. There really is that case and a driver to do things like establish a public-facing EJ policy. And doing that kind of thing is no small feat, especially as it's moving the aircraft carrier for large companies, especially with sort of legacy issues. So they really have to come together and get stakeholder buy-in and learn what environmental justice is and how do we engage with communities and how do we do that more thoughtfully? How do we elevate the voice of the community, not assume what they need, but actually listen more? And how do we identify the communities that we're impacting? How do we think about impacts? All of that. So that's been a really interesting journey. That's the biggest change I've seen so far. And I've been surprised that so much of that is really driven by that sense of competition for this funding. And it underscores I think a really big challenge that we see the federal government wrestling with, particularly, is balancing climate and environmental justice goals and trying to wrestle through some of that. I think some of the questions in the Q&A very insightfully point out this tension, things like using carbon capture and nuclear energy and things that groups like the White House Environmental Justice Advisory Committee, the WEJAC, have highlighted are not something they're desired by particular communities. So, but are still sort of to some degree necessary, arguably, for achieving some of the climate goals that the administration wants to achieve. So that's kind of an interesting tension that I think we're seeing wrestled out as well alongside all of this focus on EJ.
Yeah, I recently heard that tension described as climate tunnel vision versus environmental justice, which I thought was really apropos there. And I agree. I think a lot of the ways in which I'm seeing, particularly the 2022 legislation reflecting EJ priorities right now, is in comment processes about how different decisions are going to be made, which is great because that is the foundation on which these things will be based. Some of those comment processes have already come and gone. I have seen a number of state agencies, or I'm sorry, of federal agencies and state agencies that are doing parallel work as well, have been hosting listening sessions, which I think is so important, and have been very responsive when there have been concerns lifted up about whether they need to extend processes, whether they need to make their processes more inclusive. I know, for example, there's an ongoing, I think it closes in the next week and a half or so, OIRA process, where they're looking at recommendations across the board for federal agencies. If you haven't looked into that, that's one that I think is going to have some far-reaching impacts, and is another example of where, rather than trying to reinvent the wheel maybe across all the agencies, no, there's probably not a one-size-fits-all approach, but there are a lot of really great best practices for meaningful community engagement that we can be looking at across the board. So I would say for right now, I feel like the bulk of it is happening in comment processes, but it's going to very quickly. There are grants that are going out the doors. Things are just moving really, really fast.
Thank you. And I do want to leave enough time for closing comments. So Stacey, we'll start with you if there's anything you'd like to add or reflect on.
No, just I think appreciation for ELI for putting such a focus and spotlight on this important, incredibly dynamic area, and also directing resources and support through community lawyering through the Pro Bono Clearinghouse. I think though my work may be focused on industry, I think it's really important for a lot of the reasons that what my co-panelists underscored. When communities have those resources, they can really take advantage of some of these new opportunities, and I think it's a hard area to capture and hold on to, even as somebody who does this 24 hours a day with all the extra resources that we have in our practice. So thank you, and look forward to continuing the conversation.
Thank you, Stacey and Christy.
Yeah, absolutely. Thank you to ELI. Thank you for all the folks that tuned in today and asked really fantastic and insightful questions. I'll say it again, even though I'm sure that it's redundant to what we've already been talking about, but addressing the environmental racism concerns that the legislation and regulations are intended to address requires addressing the historic exclusion of frontline organizations from those decision-making processes. And the production and distribution of energy and of all of the different ways in which these new investments are going to be touching people's lives. They have environmental consequences, they have economic consequences, they have health consequences. We have to be thinking about all of the intersectional impacts, all of the intersectional benefits, and all of the intersectional burdens of each of those. And meaningful representation in those decision-making processes is having a seat at the table, but it is also about having the knowledge and the resources to participate. And only with that meaningful representation will decision makers be able to equitably distribute the benefits and the burdens of all of these new programs.
Thank you so much. And again, thank you, Stacy, Christy, Nadia, who's no longer with us. I'd also like to say that the Clearinghouse, we just celebrated our year anniversary on Valentine's Day. And I'd like to invite everyone. We are having an in-person only celebration in DC on March 14th at the ELI office. We'd love to welcome you, to celebrate with you, for you to learn more about the Clearinghouse and hopefully get involved with it. And again, thank you everyone for tuning in. Madison, over to you.
Yes, thank you so much. Just another big thank you to our fantastic speakers and Christine for holding this wonderful discussion. A couple quick closing remarks. We did drop the link to register for the Pro Bono Clearinghouse's networking session in the chat. So if you'd like to register there, please do so. And then one final time, the CLE code is E, capital J, capital C, capital L, capital E, colon 2022, capital R, E, C, A, P. So EJ CLE 5 2022 recap. But it's in the chat. So if you just copy and paste it into the Google form code, you can get it there. So thank you all again so much. We so appreciate your time and we hope you have a wonderful day. Thank you.
Thanks, everyone.